I'd have to report you to Professor Sullivan.
All I gotta do is take it out, and it just can't try to fight him. Thank you.
Anyone else want a cigar? I mean, not that you can smoke it now, but someone gave them to me. I'm really trying to be better. I'm going to be done by the end of this month. No? Seriously, I really am trying to do better. Section 9, we're talking about the procreative conduct, surrogacy agreements, and things along those lines. But it also scheduled to talk about Rules 26 and 27 in discovery. So let me mention that briefly. In civil matters, discovery, or the scope of discovery, is governed by Rules 26 through and 27. The entirety of discovery is found within Rules 26 through 37. But these two rules just deal with the scope of discovery and the like. And in a civil case, it's important to understand what we can get, what we're obligated to turn over and the like. And because of that, because it allows us to gather information and requires us to provide information to the other side that is either relevant or that which will lead to relevant evidence which is not otherwise privileged. And so it is not just admissible evidence, evidence that ultimately will be received at the trial. It's anything that's relevant or that which might lead to relevant evidence. And so sometimes people describe it as a fishing expedition, and to some extent we don't know necessarily what we're likely to get. And so we request categories of material and the information so that we can hopefully find support to prove our case and potentially to disprove some of the defenses they may be raising. And the scope of discovery obviously is defined by the claims that you've pled, the various legal theories you're advancing. And so we frequently will argue about whether you're entitled to get something or not, but at the end of the day, it's going to be determined by the claims you've pled and then the actual definition of what's discoverable information. In the federal court, before discovery can begin, you are required to make what's known as automatic voluntary disclosures to the other side. You cannot pursue discovery until that information is provided to the other side. And the reason that rule exists is because it was supposed to stop the sort of paper battles that litigants get into, and to say, listen, these are the witnesses you should be talking to or deposing. These are the documents that you should be looking for. This is what we've got. And also, this is what we think the case is worth. So that the idea is to exchange early on information that maybe the parties will be able to then assess, and instead of spending potentially tens, if not hundreds of thousands of dollars in discovery, that they'd actually try to address the case and look at the merits of each of their situations and decide whether it makes sense to resolve the case sooner rather than later. But only the federal court requires those voluntary disclosures, and they're not voluntary because you can't pursue discovery if you don't. They're called voluntary. But again, in theory, it makes a lot more sense. As a practical matter, parties are not fully forthcoming. In civil cases, you have to fight tooth and nail for all the discovery you obtain. And as I often say, it's not the first box of documents that I get it's important, it's the last one, the ones that I continue to push for, the ones where I look at the responses and know that they're withholding information in some fashion. So I've always said, and I've tried it in a couple different ways, and one of these times we're going to get it right, is there should be, for those of you that are interested in civil litigation, there should be a specific course here that takes you through the nuts and bolts of discovery. Because, you know, for the 100 civil cases that you might engage in, if 5 of them go to trial, that's probably a lot. But they're all going to involve some form of discovery. And if you do discovery right, and you push the matter sufficiently, you probably don't need to try it. There will be some, obviously, that you will. Go ahead.
What realistically will you get voluntarily that's going to help?
Next to nothing. Next to nothing. And even with a good discovery request, next to nothing for the most part, will people turn over. Not that that's right, not that's appropriate. I'll turn over what I'm obligated to turn over and what you request. But that's not the way a lot of people work. You almost have to look to see, well, where are they trying to cheat? What are they holding back? And you've got to be obsessive about every little jot and tittle about what might or might not be missing, so that, for instance, when I'm then deposing witnesses, and either by way of a subpoena that they're there at the deposition or through the discovery request, I will actually go through it to find out what efforts they made to try and comply with the request. And in many cases, they haven't done much at all, or they tell me they provided information to counsel that hasn't been turned over to me. And so now we start a little bit of a war. But the fact is that too often people try to hide things either through an alleged claim of privilege or arguing that the information is non-responsive, and you just have to push and push and push and really sort of dot your I's and cross your T's. I've had many depositions where parties, usually, sometimes witnesses, but usually parties, have brought in documents that I should have had months ago, and not just a couple, 3 boxes, 4 boxes. And the problem now then is that I've already have a plan for my deposition and what I was going to do, but if I don't look at that information and start to ask some questions about that, the next phase is going to be, well, you had it for the deposition, you should have inquired, I'm not going to make the witness available again. And so now I've got to protect the record at deposition that you just brought in 3 bankers' boxes full of documents. To the extent I can, I will try and look at them at a lunch break. But I am not agreeing any longer that the witness will be excused by 4 o'clock, or that I will not suspend the deposition and bring the witness back because of how tardy these documents have been produced to me. And the likelihood, and that's precisely why they were produced late, is these are likely the most important things you've got. And you got to have a thick skin, and you got to be prepared to be a jerk sometimes, because they're the ones that have tried to take advantage of the process and the court's orders. And I know what's in those documents is important, probably more important than anything else I had scheduled today, and that's why they're turned over now. But at the same point, if I just go and whine to the court, they're going to say, but you have what you need now, right? You have it. Why can't you use it now? And so that's why, in that situation, I'm more likely to suspend the deposition and likely bring that witness back, even if we had agreed it would only be a 1-day deposition, because we also agreed that you'd give me everything I need, at least, well before today. And so very few people turn over things voluntarily. Unfortunately, very few people turn over things even with a legitimate discovery request, or turn over the best things. That's what I should say, the best things. And so you just have to constantly follow that, and then double check with the witnesses and make sure that documents haven't been destroyed, that they've actually looked at the request of the subpoena and tried to, and where did they look for the information. So you spend some time developing that. It's usually pretty fruitful, because now you've got sworn statements that either they are withholding information, or that they didn't even try to comply with the discovery in a good faith basis, and I can use that for my motions to compel and the like as well. So I just can't stress enough that in civil litigation, I wish it was different. And what I've found is that, and it's not fair probably to paint everyone with the same brush, but what I've found is as the stakes get higher, the cheating is even more prevalent. And it is what it is.
So on the other side of that, how do you handle a request with information that you don't really want to?
Well, if the request clearly covers it, I'm turning it over. Okay, if it's not privileged. But I've said before, when those of you that have me sit pro, if you ask me for the red notebook, and the notebook's maroon, and I know that's the one you want, I don't have a red notebook. I'm not obligated to think about what you want. I tell my clients when they're being deposed, don't answer the question you think they're asking you. Answer the question they ask. it's not my obligation to fix your defective discovery request. And I don't, there's nothing improper about that. You know, if you ask for documents from 2012 and you really, geez, you should have, too bad for you, the 2010s were real beauties. But you didn't ask for 2010, I'm under no obligation to turn them over. And frankly, I would think, I think it's improper to turn them over, especially when it be adverse to your client's position, absent that request. And so that's the other part of it, is that I don't try to overread them and be weaselly, but at the same point, if I legitimately within the law can say, no, that's not responsive, I won't give it to you. But if it is responsive, I will turn it over. But what I'm saying is that's not always the case with other lawyers. They'll take the risk that people as a general matter are lazy. And now that is cynical, okay? But they are. And so people don't often follow up. They don't dot their I's and cross their T's. So I give you 12 banker boxes full of documents. That's a lot of paper you're going to have to go through, and it's a lot of work. And you know what? You got 12. If you go through it carefully, you're going to find that maybe the next 2 would be even better for you. But if you're comfortable with 12, I'm good. And that's the problem. Is it's not that they're not turning over anything. It's that they're turning information over, but it's not truly what you really need to get at. Not early, not unless you continue to push. George?
You answered it. I was just wondering how much the other side could say, well, you asked for Thomas Flynn's information, and we only have Thomas J. Flynn's, or something like that. But it has to be reasonable.
That one to me, if I ask for Thomas J. and he's Thomas F., okay, I'll give you that. If I ask for Thomas Flynn and you say, oh, I don't have a Thomas Flynn, I have a Thomas J. Flynn, I'd say that's improper. Okay, and that sometimes is the line that we travel down. But I think there are other easier examples where you can see people withhold stuff. And that's where you have to be careful as well as the advocate, because you're making a judgment call. It better be right, because in part, it's not that the client didn't give it to you, because that's what I'm going to go through at the deposition is, did you get the notice to produce? Did you get the subpoena? Did you make a thorough examination of, where did you make a thorough examination for the documents? What did you find? What did you do with them? I turned them over to my lawyer. Well, they didn't get to me, and I don't see them on a privilege log. So is your argument now that they're not, the lawyer's argument that they're non-responsive when it sounds like they would have been?
I was just wondering about the keeper of record subpoenas when those go to someone other than a party.
Yep.
And they produce the documents, and the other side gets a notification that you've asked for it. What if they want a protective order and you've already gotten something good?
Yeah. Okay. This is another way we double check as we get to the end. Okay. You said you gave me everything, but now as we get closer to the end, I might do what we call, as Matt called, keeper of the books and records depositions. Okay. You told me you gave me all your emails. Maybe I need to subpoena Comcast to make sure you did. You told me you gave me all of your billing records, or all your patient records from the Dr. Jim. Maybe now I'm going to do a deposition of the keeper of the records of Dr. Jim and make sure you did. And this is where, by cross-checking like that, we can figure out if there are gaps in what we should have had. You know, texts, emails, and even the hospital information or billing information. Think about things like that, or prior records. I'm not simply going to take your word or take your information. At some point as we get closer to the end, I'm going to verify and hope that you've withheld stuff. And so, but what was the import of the question then?
Well, like if you...
how do you get a protective order?
If you're the other side and...
Well, it depends on your basis. If I'm doing your doctor, I guess you could argue privilege, but you place that condition in issue, so that's likely to fail. But you might have some privilege argument. If it's your email provider, if it's your internet service provider, if it's your phone provider for text, I don't think that there isn't a privilege for any of those things. So you could say it's duplicative, but I don't think that. But the argument is it isn't, because I've got something good now. And that's what a lot of people do, is when we get keeper of the records subpoenas all the time as well for your information. Your information has some protection to it for student records for privilege under both federal statutes, mostly federal statutes, not state. And what happens with keepers of the record depositions, they don't want to show up at all. No one wants to show up at a deposition. So what they'd rather do is, here's the records, leave us alone. But as Matt points out, well, then there are going to be problems sometimes if some companies just do that. I got a subpoena from someone in Alabama. They wanted a student's records. I ignored it. They have no authority to send a subpoena from Alabama to here. And what they were doing is fishing, hoping that I would authorize the release of the student's records based on a useless subpoena. And a lot of companies would prefer, here, take the information. That means I don't have to go. I don't have to send anyone, and I don't have to go tomorrow. What happens then when you get a real gem? And has the other side gotten an opportunity to object to it? And that's where sometimes we do have issues, because subpoena is a court order, but in part, but it can be enforced by the court. But if you do it prior to the deposition, where was my opportunity to object? Now, the subpoena is supposed to be served on the other side, and so what should happen is, if you have an objection and you need a protective order, you need to run to court right now. If you think it's your doctors who are being improperly, that information's being subpoenaed, or your student records, we won't release them till we know that you don't object. But that's not the case. I mean, we're lawyers. We should know what to do. Not everyone does.
I had an internship, and we had sent one of those out, and served the other side a copy of the request, and like 2 days later, all the information came in, so obviously I thought they would have had no time to do anything.
It happens. That's why whoever receives the subpoena should be careful, especially if there's any potential claims of privilege, releasing the information too early, because there is some opportunity, especially if you think about doctors' records, students' records, tax records, anywhere where there might be arguably a claim of privilege. That information shouldn't be released, either absent a court order or at least giving the other side an opportunity to object. Okay? Let's get back to our cases on surrogacy and the like. There's a number of mass statutes. I'm not going to go through them all, but and there's not that many, actually. A lot of them really deal more with adoption than anything else. But a couple of them are found in 46, 4B, with respect to the legitimacy of a child conceived by artificial insemination. And then Mass has some in their probate parts for which are more akin to adoptions and the like, but that's the way some parts of Mass law are treated under Chapter 210. And Chapter 215 gives the probate and family court, as you might guess, the jurisdiction to handle these types of matters, because they're general equitable powers that they possess. And Mass, in many ways, does have some support for it. The problem is we also have, what we mentioned just briefly last time, this period of 4 days post the birth, where it is improper to obtain consent from the mother before then for the relinquishment of her maternal rights. A couple other things I just thought that you ought to think about as you start to get involved, or if you're going to get involved in these. Is it, as we said last time, it differs from state to state. So there may be some states that are more favorable to enter into these agreements, and the fact is that's not that significant of an expense when you think of all the rest of the money that might be involved in this. And even, I posted this site because I thought it was some information, but it's surrogacy laws by state. And this is how still unsettled a lot of this is that, for instance, it says in Connecticut, there is no provision on surrogacy in Connecticut state law, but it appears to be permitted, which is, obviously, if you were going to do something in that area, you would have to know to a much greater extent, but it's worrisome that still many state legislatures haven't tackled this at all. Maine says there is no provision on surrogacy in Maine state law, period. New Hampshire says New Hampshire law permits surrogacy agreements for married couples only. And that's, in looking at the list, that's one of the few states that actually says married couples only. Vermont, no provision on surrogacy in Vermont state law, but it appears to be permitted. Rhode Island, my recollection is the same thing. Rhode Island is the same thing. And then Massachusetts, it says here, has no laws to surrogacy contracts, but several cases, no, it's actually bad English, but several cases we'll correct it, have upheld the contracts. So we do have some protection, but it's going to be more limited. So let's talk about what you're putting in those agreements and how you possibly think you're going to get a court to enforce it. Because I guess if it's any court that's going to enforce it at all, it's a probate and family court, which has general equitable powers. Can you give up your right to abort that child by contract?
They said no in this.
They said
that it's strictly up to the woman carrying it to abort or not to. You can't compel it, and you can't tell them they can't do it either.
so it's no sense even putting in such a provision? Because here's what I worry about. Well, here's what I think about. I could confess to murder and waive those constitutional rights to remain silent, but I can't in advance give up this right, or I can't decide what to do with that by contract. And especially where the surrogate is just the womb, have not provided any of the genetic material, why should that right still rest solely with the surrogate? And what about those other things? So you could do drugs and I can't say anything. You could smoke crack.
And that is that you could put in the contract the smoking and all that.
I can put that in,
Yeah.
but I can't enforce it.
I think it said you could.
So I can put it in, and I can try.
I
So
mean, like, what are you gonna do? Just not pay them?
well, but I see. That's what I'm wondering. Well, this is what I'm wondering. Okay, we've got all these personal services contracts where they were truly personal services contracts, and you can't get equitable orders, right? But when you have unique goods, you have the ability to get specific performance and injunctive relief. What's more unique than this good?
It's not a good.
No, it's even more important than a good. So if it was a piece of real estate, I could get an injunction, but I can't get an injunction over human life that doesn't belong to you. Does that strike anyone else as illogical? So can I? Is it just that no one's tried yet? Because in essence, you are an incubator for my highly unique property.
Yeah.
No,
True,
but what?
but, I mean, it just said in there that you cannot compel or stop them from an abortion.
Okay, let's move past that one. We'll come back to that. What about drugs? No one would disagree that being a drug user while pregnant has to be harmful for the child, right? So can I enforce that part of the provision?
How do you?
Lock them up. We lock up people all the time.
Well, you have to consider the people that are on methadone. That's considered fine.
Well, is it fine? That wasn't part of the deal. I assume there's been some type of, we thought we needed a mental exam. We probably need a physical exam. I certainly would want to know the person's sufficiently healthy before I invest potential $100,000 in that person in the next 12 months of my life. So, you weren't on drugs before, or at least I had verification that I didn't think you were. We find you down where all the crack addicts are. We'll lock you up. At no point, is this what you're saying? Because we're 6 months in, 7 months in, pick whatever number you want. You're saying, no, not until that child gives birth, there is no way, no court can enforce this at all. True? For this good?
Talking about a human life, it's not a good, what he said. I mean,
Okay, but
if you're starting to talk about, well, what, you kind of go back and forth across the line with, it's like the baby is, or the fetus, whatever you want to call it, is a good, so it's, you're talking about it as
I'm saying, this is what I'm saying, Masha. If I can get specific performance or injunctive relief on unique goods, on this tape recorder, why in this situation?
Because you're taking away someone's liberty without a court case.
You agreed to do it. No, there's going to be a court case. The judge is going to have to wait. But this is what the person agreed to in advance for a fair amount of money and insurance. Or I'm not even sure the money just sort of a little sweetener.
But you're going to put someone in jail for breach of contract.
I'm going to put someone in jail because they are potentially affecting the good that he was supposed to deliver.
You're going to have to put up a serious bond for that one, wouldn't you?
But
You're taking away someone's
wouldn't
freedom.
you? Wouldn't you? I certainly think there's no doubt in my mind that there are couples who would.
well, if you're going to follow the logic and say that you're entitled to specific performance or injunctive relief for this unique good, the surrogate child is the unique good, then yeah, if you agree to that and you're going to follow the logic all the way through, then you get jailed if you put that good in jeopardy.
Well, I'm wondering what's the sense in putting these provisions in? No smoking, no drugs, vitamins, regular doctor visits, prenatal care, whatever else. By the way, are there other provisions you'd want in this contract that you're going to write up?
Yeah.
What? What else?
No mountain
Things like
climbing.
that.
No mountain climbing, no dangerous physical activities? What about the sex? Did you guys decide that? Promiscuous sex, that's okay? No? You're going to limit, you could limit,
Yeah, we're going to go down this road, yes, because no diseases.
so you can limit her sexual partners.
I don't think you could, it said in that article. That was covered in this article.
So,
Yeah, but we're following the ridiculous logic.
no, I'm not so sure it's ridiculous logic. Why is it ridiculous logic? You're putting someone else,
It does say celibacy may be required as well.
so what the hell? Celibacy, even better. I was going to give you one sex partner for the next 9 months, but he says celibacy.
Well, will
As long as it's
that,
not an IV drug user or someone else.
yeah, will that person have to go through a wellness exam to ensure that they're free of?
Okay, forget it, celibacy it is. That's what you prefer. So wait a minute though, so we could tell someone they couldn't have sex for 9 months, but we can't restrict some of these other rights?
Yeah, it doesn't, it's
You
all or
can put
nothing.
into consider abortion.
I can put in that
Consider abortion if fetal abnormalities are discovered.
well, let's say, okay, you get to decide, but if you don't, you keep it. We can do that? Is that what you're saying?
I don't think that's what this says.
Because because what it sounds like is, we think we can write an agreement that will have absolutely no effect in the law whatsoever. So, this is fraught. I mean, why would you encourage anyone to do this?
I wouldn't. I was going to save that for the end.
What, you would just tell them, walk away?
I would tell them this is a terrible idea. You're trying to enforce something that you can't genuinely enforce. You can agree to anything that you want. But is that going to happen? We don't know.
Well, we don't know or no. Because that's what I'm wondering, is that there's no argument to be made that, why shouldn't we be able to enforce this? Well, if you're not, who has to take care of this child for the next 20, 30, 40, 50 years, depending on what happens over the course of this pregnancy? And, some people are not so easily going to say, okay, you keep it then. You damaged it, you keep it. And so why can't we, if we're going to allow these agreements to take place, and a lot of states do, people make money, people have children, this happens with some real frequency now. We're not talking about that it's really not relatively the norm, why can't we put provisions in here? And why shouldn't we be able to expect the court to enforce some of these provisions? Because you just don't want to jail someone.
I'll send them to jail.
Huh? You'll send them to jail.
Oh, yeah.
Well, do you remember there was a case in Fall River where the mother had killed her first child, buried her somewhere up in Maine, and then at some point when she was pregnant with another child, and somehow they felt complicit in the first murder, they actually did incarcerate her during the balance of her pregnancy, not per se to keep the baby safe, but as that she would be a danger to the baby, and so therefore they revoked her bail, that, you know, under the dangerousness argument. But obviously then they could monitor that child over the course of the remaining term of the pregnancy. Why not? You give up your constitutional rights all the time. I agree we'll go to Alabama instead of where we might be able to go. Waive my constitutional rights, I kill them. We waive our rights all the time. What's the matter with waiving them in advance, psychological exam, with counsel, clearly made aware of what the ramifications of some of these choices would be?
I guess it wouldn't be a big deal if you're not a smoker, drinker, because if you're not any of those things, you know you're not going to do it, so you're going to keep your freedom.
Well, right. I don't want a smoker or a drinker having my child. I don't want a crack user having my child. So if you weren't at the outset and you weren't doing, then why can't we agree to these provisions? And more importantly than the agreement, we have to make sure that then, to some extent, we're going to be able to find enforcement. Go ahead, Matt.
The scenario that you just mentioned with Rhode Island, with
Fall River,
that was the state asserting its interest in
Agreed.
the person, and in this one, it's a private party asserting their interest in the fetus that's been implanted in the surrogate. So there's a difference there.
Well, I don't dispute that there's a difference, and I don't dispute at all that the state has a greater obligation to protect society. But don't mom and dad have a significant obligation to protect their child, who now resides in someone else's uterus? I mean, if the state were trying to take away that child from us, we would both have appointed counsel. The right is so important. So,
We've got the murkier issue of who's mom and dad now too, though.
well, do we if it's my wife's egg and my sperm, or under Bazanka, we bought the egg, we bought the sperm. In essence, it's ours. We're the procreative parties here. We're the ones that gave birth to the idea of giving birth to a child. We are. I think most states then would see you're the parents. The problem is where the surrogate has some genetic link to the child is where it gets bad. That's why the tendency is now to move completely away from that model, because it creates additional problems as to who's mom, even if there's an agreement otherwise. But so it's my egg. It's not my egg. It's my sperm. It's my wife's egg, implanted in someone who is doing this, we'll say for profit. Because I think that makes it. Well, does that make it different? It does make it different, doesn't it? I was paying you $100,000. It's a commercial transaction. I'm restricting your rights, but I'm paying you pretty handsomely for the next 9 months. Deal's a deal. Why shouldn't I expect a court to be able to enforce the provisions that we agreed to? If she was represented by counsel, if there was a psychological exam, and it's not just now, you know what, I'm 5.5 months into this. I'm kind of bored. I think I'm changing my mind. Still completely her choice. Why can't she have waived that choice at the outset? Why isn't this closer to a unique good case than it is a personal services contract? Because if it's a personal services contract, we read those cases, they say, no, you're out. Out, out, out.
I think if you agree to it, and if you agree to it up front, then you can.
Well, I wouldn't say can. You would have a shot, because as Jim's pointing out, you're going to find a ton of articles and a ton of information that says, geez, who does that right belong to? And can it ever be sort of bartered away in this fashion?
Right.
Go ahead.
I guess unless the legislature puts something through with that, it's gonna take a case for it to happen, and someone's gonna be willing to spend a lot of money, because it's gonna be appealed and appealed until it either goes to the state Supreme Court, more likely the U.S. Supreme Court. It's just, there's no precedence whatsoever, so.
No, I did a show one time with one of the stations, and it was on fathers' rights, and what they wanted to discuss was, does a husband have any rights to prevent his wife from aborting the child? You've got one case somewhere out in Minnesota or Wisconsin that might give you a smidgen of hope. Beyond that, even the father married to the wife, not arguably, it's pretty clear, has zero rights in opposing the termination of that pregnancy. Arguably, these two people, potentially, you could see them as strangers, certainly to the surrogate. I don't see strangers to the child. But so then help me with this. If you don't follow my route, you guys are writing these agreements that are completely useless. People are spending hundreds of thousands of dollars on a wish and a prayer. Well, that seems damn dangerous for lawyers to be engaged in that, and there's lots of lawyers that are engaged in this. And here's your other thing, part of it. People don't care what you say. Not under these circumstances. They want this child, and this appears to be their last hope. So we're just going to try and make it work and keep our fingers crossed, or we're going to. I wonder what you're telling me you would tell them.
Do you think now
See someone else?
that it's more common that the legislature will step up?
I would have thought they would, but when I ran this little list still, because it's been years now, there's an awful lot of them that still say it appears to be permitted. It appears. Now there's more than in other years when I look at this list that talk about permitting it. But you would think we would have a more uniform statute that would be adopted by a number of jurisdictions as to what can and can't be done, and under what circumstances then those agreements can be enforced. Because again, the technology has raced ahead of the law in this regard, and so we've got big gaps and we've got big problems, and even just pulling this down, I pulled a whole just Google brought it in for me. Make 70,000 being a surrogate. Make there's paid ads that are seeking people to do this, meaning there must be an awful lot of people that are doing it and likely being paid for these services. And there's certainly a demand for parenting in this way. I forgot till today when I was looking this up, a very close friend, she had one child in California by surrogacy because she was ill. And after her death, twins were born. They had been implanted prior to her death, and then post her death, her children were born to surrogate. So she had actually 2 kids after she died, which is not, that's another part of this. I didn't give you that article this time. They can extract sperm from a donor post-death. And then the question is it's not a question who the dad is. The question is, because we know who the dad is, but then the question is the child an heir?
Do it in a coma, and the guy was saying that it's borderline rape. And I'm like, how's that borderline? It is rape.
Right,
how
'cause
they do it.
Right, did it say how they do it?
They stick an electrode through your rectum
Yep.
and shock you.
That's just what they do. And
Wow, that's pleasant.
well, you're in a coma or you're dead. So you're probably not experiencing much other than,
All I know is I had a lot of kids and I could have got paid for it. I missed that.
well, not your kids, though.
That would have even been better. Would have been a lot better.
So tell me though, seriously, someone comes into your office, they want to do this, they show you the agreements, which require a significant amount of money with the fertility service and the like. Matt said, I'm out, okay? You said you're out because you just see it fraught with difficulties. Are you back in? Are you out now? And tell me what you tell them. You just say there's nothing I can really do? Or you try to fix the agreement? You try to tell them what the problems are? What is the advice? Because there's minefields everywhere here, right?
I think you'd have to tell them that they're not, and there's no precedence that, like, anything could happen. And I really can't tell you how the outcome's gonna be.
And is there no way you could help protect me? I mean,
I think that's what it comes down to. I'd say, listen, if you want to do this, we need to have a long conversation. Like, I wouldn't even have it that day. I'd say we need to set a different day, just so that they can tell the seriousness of my voice from the outset. And then after that, literally go through every warning with them. Just, hey, yeah, it'll say this in the agreement, but at the end of the day, I can't enforce them, and neither can the court force them to not do drinking, to not do this. And then what are you going to feel? You're going to feel upset, and you're going to ask me to do something for you, and I'm going to say, I warned you, there's nothing I can do.
so it's like a builder. I need a surrogate I can trust. Because the rest of it, if the builder's not going to build it right, I'm done anyway.
That's it.
But it's not just my house that you've got at the end of the day. Who takes care of this child? And so that's all it is. Oh, we're going to have like a heart-to-heart talk. I'm going to tell you,
Well, that's the thing.
here's hoping in 9 months we're in good shape, because God only knows what we could be. And maybe right now that is the best. I can try to put provisions in there that'll protect you to some extent. At the end of the day, probate court may or may not enforce it. I have an idea as to what we might try to do, but we're in an area where there is not a lot of established law that supports what it is you're trying to do. In fact, if we go to the early equitable cases about personal services contract, they all say, no way can you get specific performance of a personal services contract. And these are personal services. Pretty personal. So it's the legislature's fault because they haven't fixed this. It's the people who want the baby bad enough that we don't think we can address it.
I think it's what you said. I think it's just that technology has raced ahead of the law. And maybe down the line from now, sometime in the future, we'll be able to handle this situation better. But for now, as the law is, as we all learned, you can't enforce specific performance contracts of a personal nature.
Many of these provisions that are listed here, when the surrogate is compensated, the agreement is void. So even in none of the jurisdictions which permit surrogacy, they do not want it to be paid, which is kind of interesting because what they're worried about is that the person solely for the money. And maybe that is something worth thinking about, is that...
Why else would you do it?
Huh?
That's the incentive then, yeah.
Why else would you do that?
I've known people who did it for friends.
Well, yeah, there's like a friend or a sister.
Right. But that's why, and there's perhaps the argument then is for reasons why some of these prohibit payment, is that they're more likely to honor the agreement when it wasn't just about compensation, it was about helping a loved one to fulfill their goals. So the compensation can become a real issue. By the way, the compensation, again, sort of being lawyers, so I can pay for your time, I can pay for your medical care, I can pay for you to be able to go to school and get your doctor's visits. I just can't give you money beyond that. I mean, so when we talk about compensation, there's still going to be money that needs to be paid to the surrogate or her providers and the like. The question is, what do they determine compensated agreements to be? And that's not going to be uniform either. Let's look at the Culleton case, which you were supposed to look at as well. And Culleton is one of the Massachusetts cases, and what they were looking for here, and again, this sort of gets into some of the social issues involved. Well, we want the kid to know that they're our child, and so we'd like the birth certificate to indicate that, not that the birth certificate talks about the surrogate as being the parent, and if we could get a declaratory judgment in advance, informing the hospital how that birth certificate and so that the parties understand what that birth certificate should say, because otherwise the hospital is going to go by what they see the law is. And so the Culleton is a Mass case from 2001. And again, this is probably where we start a lot of the information, and we think about under what circumstances we would seek and where enforcement of whatever provisions you put in this agreement. It is going to be the probate and family court, as this case was initially filed in the probate and family court. And the probate and family court then was able to issue the declaratory judgment. And what the court talked about in Culleton, and I hope you read it because it's one of the few cases that we really have here. We have another 2004 case. Allows that probate court to try and determine the interpretation of the surrogacy contracts, and in fact did, and then ordered that the birth certificate could reflect as the procreative parents sought, they as the actual parents of the child, not the surrogate, so that it would indicate going forward how that who's the parents of that child were. I gave you a couple articles in here as well that talked a little bit about, how does some of the rest of this work then is, what are you going to tell them as to their origins? We have another case down the road that we're going to look at where the parents sue not for wrongful death of a child, but wrongful birth of a child. Husband had a vasectomy. Child was ultimately born, and they sued the doctor for wrongful birth, saying, we've got this child we didn't want now. You owe us some money. And so some of that you start to think about is, well, how are we going to deal with some of the other issues that are attached to this with respect to how the law should look at how some of these things are going to be affected with respect to the child's initial origins. And that's, I think, luckily, outside your pay scale, because that deals more with parenting and psychology than it does deals with anything else. The Culleton case, the birth certificate was able to be issued in the name of the parents who gave birth to the idea of giving birth to the child. And the last case I just wanted to mention, and it's not in the package, it's a Hodis versus Morin, which is a 2004 case. And again, this is a case that gave the probate and family court jurisdiction to issue orders, even though the gestational surrogate and her husband, as well as the intended parents whose egg and sperm were used to create the pregnancy, lived in other states. So none of the parties were really present in Massachusetts. What was going to happen was that child was going to be born in a Massachusetts hospital. And the court determined that under those circumstances, even though none of the contracting parties were in Mass, the Massachusetts Probate and Family Court still had jurisdiction over that child, since the child was intended to be born here. And the reason that we have to start to think about that aspect of it is there are some states where you can't have a surrogacy arrangement at all. And so even if the contracting parties are from those states, even if the surrogate's from those states, the fact is that you may find no assistance in any court in that jurisdiction. So what we at least know about Mass is that Mass can be used to help interpret these agreements. Whether they'll ultimately enforce all of them or not is, we don't know. But what we do know is Mass, at least as opposed to a number of these states when we look at that list, favors them to some extent, or at least will deal with the consequences of those agreements as well. So I don't know what else your thoughts are on this, but it doesn't seem like you have that much interest in getting involved in them, but I think the likelihood is you will. And so hopefully the law will catch up, but I'm not so sure it will, because this issue has been around for a couple decades now.
Well, I don't think society is settled on this either. I think maybe that
I think it's.
might have
Well,
play a part.
And listen, we didn't even talk about cloning, you know. And by the way, I'll tell you the advice I had for one of mine when I was in Boston, one of my parties when I was in Boston, and it's not a true surrogacy arrangement, but she and her partner had decided to have a child, and she was pregnant. It was her egg. Her partner was the same gender, so they had donated sperm, and she wanted me to prepare the agreement that would give her partner equal rights to the child and all the rest of it. My advice, having handled divorces as well as why would you want to do this, right? And I know this sounds cynical, but you're giving birth to the child. You're clearly the mother. It's your egg. There's none of those issues involved from your side, and potentially what you're doing is involving the child in a custody fight somewhere down the road, assuming your relationship doesn't work. I'll do whatever your wishes are here, but I would also recognize that the fact is you are under no obligation to do really anything here with respect to her rights. And in fact, and I think this is not just appropriate advice, I think it's needed advice, to recognize that you're creating rights with the law isn't likely to recognize any at this point in time. And by doing so, you're potentially involving yourself and your child in a custody fight somewhere down the road. And is that wise? Is that what you want? At the end of the day, I'll write what you want within what the law will permit. But at the same point, I do think some of these situations, certainly, you know, when there's friends involved and all the rest of it, it does get a little more complicated. To some extent, the money sort of says, well, this is a commercial transaction, let's put this, you know, we can figure out everything together. When there's more personal relationships involved, I think it's a different conversation as to what the potential ramifications are and what the parties may want to do. I mean, we can see clearly here a lot of these situations say, and we know the law says, the surrogate should not be genetically related to that fetus in any way. It just creates all of these other issues when they're up, because who the mom is a lot more unsettled when the surrogate is providing the genetic material. So money makes it easy, but many states say money's not going to work at all. So I don't know what you do with it all, but I think it's an interesting area for you to think about, and I think it's likely to affect you down the road, whether you like it or not. And I'm not sure the law is going to change as quickly as you're going to need it to. So you better figure out what you're going to advise and when. And I also think if you're thinking of doing this at all, you really need to look at 50 states' laws and try to figure out which one we should be likely engaging to make these agreements work better. Because some states have much more specific and detailed rules than others. And many of them sort of are still, even us, which we tend to be a relatively progressive state, are still sort of feeling our way along here.
Yeah, I think California, are they still ahead of it? Or
Yeah,
what other states?
Yeah, California is always ahead of the curve, and they still are. That's where my friend had her children. And that's not unusual. What's unusual, a little bit unusual, is Mass lags so far behind, even though when you look at the list, we're still ahead of others. But you would think, for something like this, there should be relatively detailed statutory requirements and the like in place, because we know, as we sit here, the difficulties that are present are likely going to take place. And I really don't know how you deal with some of the ramifications, because what's likely to happen in some of these situations is people will abandon that child. Either the surrogate's going to abandon it when it's damaged goods, or the parents are going to abandon it when it's damaged goods. Not that they don't continue to have some financial responsibility, but it would seem to be an area where the state does have an interest in providing some protection. But I think it's just too much of a political football for people to get involved in. So, see you next time.